One of the most difficult cases that we deal with are when one person comes to us for divorce, but they don't have access to the finances. These divorces are tough for a number of reasons. One, we need the documents and information to be able to know what we're dealing with so that we can advise the client as to what their equitable share should look like, and so that we can advise and guide the client to hopefully a settlement, or if we need to go to trial. The second issue or scenario where that becomes a problem is, how does the client pay for legal services if they don't have access to the money or the accounts? One of the things that we advise the client to do is to get help to get the money to pay for initial retainer, and then we can file with the court an emergency petition for temporary attorney's fees. This will help the client and hopefully get the settlement that they deserve. So in a divorce case, there are situations where we need to go to the court to ask the court to have the other party or spouse pay for our client's attorney's fees. This is usually a situation where we have, for example, a stay-at-home wife and the husband was working, so the husband has and controls most of the money. In these situations, what we do is we, of course, get our client's financial situation. We have them prepare a financial affidavit. We file that with the court, and we request a motion for a temporary hearing for the judge to hear the issue of finances. And at these hearings, the judge's goal is to keep things in a status quo and give the party with lesser resources the opportunity to have an equal day in court. So most judges will award attorney's fees where one party controls the finances and is the bread earner, and the other party does not have access to the funds. In a divorce case, we often run across a situation where one spouse is trying to hide assets. This usually presents in the form of hidden bank accounts. Sometimes the accounts they could be offshore, but more often than not, they're right here. They're just in different bank accounts. So for example, the marital bank account may be in a Bank of America account, and the spouse has other bank accounts that the other spouse is not aware of in Wells Fargo, or sometimes in the smaller community banks that are not global, so they may be harder to track. Oftentimes, what also happens is that they can try to hide money by purchasing property or other assets and placing them in another person's name, such as their children or their brother or even their parents. And most of the time, even that property that is titled in someone else's name, we can get access to that as long as we can prove that the money came from the spouse. If you go to trial and a judge finds that one spouse attempted to hide assets or did anything to try to hide marital funds, the judge can, I don't want to use the word penalize, but the judge can penalize that party by giving a larger portion of the marital estate to the other party. If you have any questions or concerns that your spouse may be hiding assets, please give us a call for a consultation.